My name is Arnold, Deputy Head of Advantage Austria. Herzlich willkommen nach Österreich, stellvertretender Wirtschaftsdelegierter hier in Tokio, Arnold Akra. Ich bedanke mich für das rege Interesse. Wie Sie wissen, ist das jetzt die Fortsetzung unseres ersten Webinars, das wir vor fast 2 Jahren, nämlich im November 2024, gehalten haben. And I'm switching to English now as we have more and more of our Japanese participants coming online. So as you know, this is the second installment of this webinar, and we had the first one in November 2024. Now it's 2026, and the good news is that in beginning of December, 1st of December 2025, this agreement came into effect, entered into force. And so it's a very good time now to actually talk about the details, take a look at the procedures. And I'm very happy that on the one hand, again, we have our partners from City-Yuwa, the attorney, Ms. Tsukamoto, who also guided us through the first version of this webinar last time in November 2024. And she is being joined today by Mr. Hildenbrand, another one of the lawyers at the City-Yuwa attorney and law firm. On the other hand, and I also want to thank you very much for joining. We have 3 participants from the Austrian official side. So we have 3 participants also from the official side of Austria joining us today. That is 2 officials from the Austrian Ministry of Labor, Social Affairs, Health Care and Consumer Protection, who are heading the Department for Social Insurance. And also we have 1 person from the Federation of Austrian Social Insurance, also an expert on social insurances, and all 3 of them are also joining us for the Q&A session at the end of this webinar today. I want to quickly share the topics that we are going to talk about today. So we have, of course, a little bit about the enactment, then the purpose of the international security social agreements. We'll skip over those very quickly. Then go a little bit about who is covered. It's a very important part, of course. So, of course, we're talking about experts. We're talking about people that are working for Japanese companies in Japan, Austrians working for Japanese companies in Japan, but also Japanese persons working for Austrian companies in Austria. And then we are talking about, of course, difference between employees, self-employed, and so on, business trips. This is, of course, an interesting topic. What is a business trip? Does it have an effect in terms of social security agreements? And then we also have, of course, other scope of the social insurance coverage, and so on and so on. So I started out a little bit about this, and I would continue to share it with all of our participants, and then, of course, hand you over the microphone, so to say, the floor. And we already went through the agenda, so I think we can, jump into the next slide, talking about the enactment of the agreement.
Okay. Hello, everyone. So then let us begin with the enactment of the agreement. So after around 50 years of intensive negotiations between Austria and Japan, the bilateral social security agreement was executed on January 19th, 2024, and following the completion of all required domestic procedures in both countries, the agreement officially entered into force on December 1st last year. This means that 2 months have passed since the agreement took effect. And yeah, we discussed the purpose of this agreement at our previous seminar, but since it's been a while, let's review it again. So first, the agreement aims to eliminate double contributions. So without this agreement, individuals may be required to pay social insurance contribution in both Austria and Japan at the same time, which creates significant financial and administrative burden for both employees and employers. And second, the agreement helps ensure pension eligibility. So by allowing insurance periods in both countries to be combined, individuals can meet minimum qualifying periods required to receive pensions benefits. So these 2 points are main important topics of this agreement. And in doing so, the agreement supports economic cooperation between the 2 countries and enhances flexibilities for companies and individuals. So the structure of the agreement can be understood in 3 stages: entry, qualification, and exit. First, at the entry stage, if the certain conditions under the agreement are met, only one social security system applies at any given time. And this means that an individual is covered by a single applicable system, either in Austria or in Japan, and there is no double coverage and no double contribution obligation in terms of pension. Second, at the qualification stage, coverage periods completed in both countries are combined or totalized. This totalization ensures that individuals can meet the eligibility requirements for pensions and other long-term benefits, even if they have worked in both countries. And finally, at the exit stage, each country pays benefits only for the periods during which the individual was covered under its own system. So there is no cross-payment of benefits between the 2 countries. So let us now look at who is covered under the agreement, starting with employees. So as a general rule, employees are subject to the pension system of the country where they actually perform their work. In other words, Social Security coverage follows the place of work in principle. However, there is an important special rule for employees on temporary detachment. So if an employee is temporarily assigned to work in the other country and the expected period of such detachment does not exceed 5 years, such employee remains subject only to the pension system of the sending country. This special provision, this special rule is designed to ensure continuity of coverage and to avoid unnecessary changes in pension obligation for short to medium-term assignments. Next slide, please. The agreement anticipates 2 possible models for such temporary assignments. And in the first model, no local employment contract is concluded in the host country. Instead, the assignment is structured, for example, through a service agreement. And in the second model, a local employment contract is concluded in the host country. However, even in this case, the employee may still be considered as remaining under the direction of the sending employer. So in practice, what matters here is who actually exercises direction and control over the employee. Typical indicators include whether the sending company determines the employee's role or duties or reporting line or performance evaluation and so on, and whether it bears ultimate responsibility for HR matters. And the fact that the host company pays the employee's salary for internal cost allocation purposes does not prevent the employee from being regarded as remaining under the direction of the sending employer. And there is an important point to highlight here. So the exemption under this agreement applies only if the period of temporary detachment is not expected to exceed 5 years. So its expected duration at the time of the assignment is critical. Particularly problematic case is an open-ended secondment. So if there is no internal documentation showing that the assignment is expected to end within 5 years, the exemption may be at risk. So from a practical perspective, employers should formally define a secondment period of 5 years or less and include a clear written clause and the relevant contractual arrangements. And this kind of advantage structuring is essential to secure the application of this agreement. That said, while the company initially intended to stay for 5 years or less, but circumstances have changed and the company may wish to extend the assignment period a little longer. So let me now address extension beyond the 5-year period. So as a general principle, extensions beyond 5 years are possible only with the mutual agreement of the competent authorities in both Austria and Japan. And the terms of such extension are addressed on a case-by-case basis. In practice, when employee and employer submit a request for extension, kinds of documents and information may be required. For example, the explanation of the reasons for extension, details of the family situation, and so on. And it is also important to note the transitional rule. So for detachments that started before December 1st last year, the agreement treats its effective date as starting point for continuing the exemption period. So for example, if a secondment began on July 1st, 2024, the 5-year detached period will run from December 1st, 2025, the effective date of the agreement. And there are a few additional points on cover regarding this employee topic. First, special rules apply to certain categories of workers, such as crew members of seagoing vessels and international airline crew members. These cases are subject to specific provisions under the agreement. And second point is nationality itself is not decisive. So the agreement is not limited to Austrian or Japanese nationals. So employees of other nationalities who are temporarily detached between Austria and Japan may also be covered, and if the relevant conditions are met. On the other hand, it is important to note that simply being an Austrian national working in Japan does not automatically trigger the application of this agreement. If there is no temporary detachment and the individual works in Japan under a local employment contract, in that case, the provision regarding double payment exemption does not apply. So in short, the coverage depends on the structure of the employment and the nature of the assignment rather than nationality alone. Next slide, please. So let me now turn on to self-employed persons. So as a general rule, self-employed persons are subject to the social security system of the country where they actually conduct their business activities. There is, however, there is a special rule for cases where a self-employed person conducts business simultaneously in both Japan and Austria. Without the agreement, such individuals might be required to enroll in the social security system of both countries. But under the agreement, in these situations, the self-employed person needs to enroll only in the system of their country of residence. This rule is intended to avoid double coverage and to provide a clear and predictable framework for cross-border self-employed activities. If country of residence in Japan, this is decided whether this person has a residence registration, Juminsho in Japanese, or not. An Austrian individuals move to Japan and conduct business activities only in Japan. So in this situation, the person is covered exclusively by the Japanese social insurance system. And in case B, if an individual resides in Austria but conducts business activities in both Austria and Japan at the same time, under the agreement, this person is covered only by the Austrian social insurance system, which is a current residence. And an important point to note here is that unlike temporary detachments for employees, there is no 5-year limitation for self-employed persons under these rules. Next, And let me now briefly address how short-term stays, including business trips, are treated. Short-term visits typically include activities such as business meetings and negotiations, contract signings, factory tours or inspections, its business report or internal briefings. The important these visits are without the purpose of receiving remuneration in Japan. So as a result, short-term visitors are not considered to be engaging in employment, which means activities for remuneration in Japan. So therefore, there is no obligation to enroll in Japan's social insurance system arise in these cases. And so consequently, this social security agreement does not apply to pure business trip. Yeah, but locally hired employees. So how about locally hired employees? So in other words, employees who are hired locally without being sent from other countries. In such cases, the employee is subject only to the social security system of the country of employment. However, the agreement is still relevant to locally hired employees when it comes to the combination of pension periods or totalization of pension periods. Yeah, let me illustrate this with a simple example. An employee works for company X in Japan for 7 years. And after leaving, so resigning company X, the employee moved to Austria and worked for company Y for 10 years. So on a standalone basis, neither the 7 years in Japan or the 10 years in Austria will be sufficient to meet the minimum pension eligibility requirements in either country. But by applying the combined period rule under the agreement, the employee becomes eligible to receive pensions from both Japan and Austria, with each country paying benefits only for the periods completed under its own system. This example shows that the agreement is not only about avoiding double contributions, but also about protecting long-term pensions rights even for locally hired employees.
I am continuing now, and on this slide we are now summarizing which parts of the social insurance systems are actually covered under the Austrian-Japan agreement. Starting with Japan, the treaty covers the pension system, the health insurance, and employment insurance. For Austria, it includes, on the other hand, the pension system, the sickness insurance, how we call it in Austria, the Krankenversicherung, the accident insurance, and the unemployment insurance. Now, there are a few important practical rules to keep in mind. Employment insurance is simple. Only the system of the sending country applies. So an Austrian sent to Japan continues in the Austrian system for employment insurance. Health or sickness insurance is different. Due to Austrian residence permit requirements, both the sending and host country systems apply. As for the accident insurance for individuals temporarily dispatched from Japan to Austria, Austrian accident insurance applies even if they are otherwise under Japanese coverage. On the other hand, for individuals in Japan, accident insurance is not covered under the treaty at all. So, this slide shows how the agreement treats employees sent from Japan to Austria. And here the treaty clearly distinguishes between the temporary and non-temporary assignments. For the temporary assignments of up to 5 years, as we heard before, the Article 7 of the agreement applies. That means, in that case, the employee remains subject to the Japanese pension and Japanese employment insurance. Austrian pension and Austrian unemployment insurance do not apply. However, Austrian sickness insurance and Austrian accident insurance do apply, which means that for health insurance and accident insurance, there is a dual coverage, as we call it. Now, for assignments that are not temporary, which is here on the table on the very right side, that means Article 7 does not apply. The general territory rule applies. And the employee becomes subject only to the Austrian legislation. That means full enrollment in Austrian insurances and generally exemption from the Japanese insurance. Now we have the other way around, that for secondments in the other directions from Austria to Japan, the employee stays in the Austrian pension, sickness and employment insurance and is exempted from the Japanese pension employment insurance enrollment during the period. Health coverage, again, is dual. Austrian sickness insurance continues, and Japanese health insurance may also apply based on immigration health regime mechanisms. The Austrian accident insurance remains applicable as shown. The Japanese accident insurance system is, as mentioned, out of the scope of this agreement at all. Outside temporary assignments, Japanese insurance applies, while Austrian enrollment is generally exempted. Now moving on to the self-employed people. This slide shows how the agreement treats self-employed persons, and the key issues are: for self-employment, the treaty is different from the employment system. There is no 5 years rule, as we heard, no possible extension, and no temporary assignment concept. Instead, the treaty says that the self-employed person is subject only to the social security system of the country in which he or she is resident. So residency alone determines which system applies. If you are resident in Japan, Japanese pension and health insurance applies. If you are resident, on the other hand, in Austria, Austrian pension, sickness and accident insurance applies. Employment insurance, of course, does not apply because they only covers employees. There is no possibility to stay, for example, in the Austrian system just because the stay in Japan is only temporary. Also, this system applies even if the person still has business activities eventually in the other country. There's one important exemption. Austrian sickness insurance and Austrian accident insurance may still apply under Austrian domestic law even when residing in Japan. Just a brief explanations of the Japanese health insurance systems for those who might not be familiar with that. If an employee has an employment contract with a Japanese company, the company's health insurance applies and premiums are typically split 50-50 between employer and employee. If there is no Japanese employment contract, for example, the person is under a service agreement or the individual is self-employed, then the person must enroll in the national health insurance and pay the premiums fully by themselves. This slide now explains how the new agreement treats spouses and children who accompany an employee on an assignment between Japan and Austria, and vice versa. First, let us look at the direction from Japan to Austria. If a Japanese employee is temporarily assigned to Austria under Article 7, and the spouse or the children accompany the employee but do not work in Austria, then the Japanese pension system continues to apply to them. At the same time, Austrian sickness insurance applies because health insurance is not eliminated under this Article 7 in this case. This is the same situation as for the employees themselves. So in practice, accompanying family members will usually be covered under the Austrian sickness insurance, while the Japanese pension insurance continues. Now let us look at the opposite direction, from Austria to Japan. If an Austrian employee is seconded to Japan and remains subject to Austrian legislation under Article 7, then Article 11 becomes relevant for the spouse and children. Under this Article 11, the spouse and the children may be exempted from the Japanese pension systems, provided that certain conditions under Japanese implementation rules are met. So, in that case, the spouse and children do not need to join in the Japanese pension systems, even though they are residing in Japan. This is a very important point, a special situation in Japan, because even when an adult person is not working in Japan, such person still is generally required to pay into pension insurance. Very different system here. However, Japanese health insurance still applies. That means that accompanying spouse and children generally have to enroll in the Japanese health insurance system, even if they are exempt from Japanese pension contributions. Please note that if the spouse or the children take up employment or self-employment in the host country, they are no longer treated as accompanying family members. In that case, they are subject to the host country social security system under the general territory rule in Article 6, and the special Article 11 exemption for spouses and children no longer applies. This slide explains how the agreement treats spouses in Japan and Austria. First, let us look at a situation where a Japanese self-employed person works in Austria. If the spouse and children accompanying that person are not employed in Austria, then the Japanese pension system continues to apply to them. At the same time, Austrian sickness insurance applies because health insurance are not eliminated under the Treaty for Detached or Resident Persons. So in practice, accompanying family members will typically remain affiliated with the Japanese pension systems while being covered by Austrian sickness insurance. In the opposite direction, when an Austrian self-employed person works in Japan, then under Article 11, the spouse and the children, as long as they are not employed themselves, may be exempted from the Japanese pension system, provided that certain conditions under the Japanese implementation rules are met. So in that case, even though they are residing in Japan, they do not have to join the Japanese pension systems. Further, the agreement allows an exemption from Japanese health insurance, provided that the spouse and children are enrolled in the Austrian sickness insurance system instead. Again, if the spouse or children take up employment or self-employment in the host country, also here they are no longer treated as accompanying family members. Now some practical to-dos for this situation, and we limit it here only for the situation for the direction from Austria to Japan. For new assignees, which are still in Austria, they have to first confirm whether the detached worker is eligible under the agreement at all, and then apply for a certificate of coverage in Austria before departure. We come to the very details in a moment. In Japan, then, align the Japanese payroll to avoid that pension and unemployment withholdings during the certificate period. Please note that Japanese health insurance will still apply, as we said, creating dual health sickness coverage. For detached employees already in Japan, please assess whether a prospective certificate can be issued. And then correct the payroll, but only going forward, check for any refunds option under Japanese law, and document the treaty well for coverage for audit. For those self-employed, they coming to Japan, you please determine the treaty residence, confirm the Japanese Social Security applies upon residence and enroll in the Japanese pension and health insurance. Maintain the documentation of residence and business activities to support future totalization and audit. For those self-employees already resident, confirm the status, enroll or adjust your contribution prospectively. Review the past contributions for any applicable refunds or credits, and keep records for future pension rights. So we have heard now a lot the word of a certificate of coverage. Here we get to know now some more practical details. A certificate of coverage proves that the employee remains subject to the sending country system, and for self-employed persons prove that they remain subject to the residence country's system and is basically exempt from host country's coverage for the treaty period. Subject, of course, to the exceptions as we learned before. Without this document, the host company may demand full local contribution. This document is therefore the key document in the whole procedure. Let me briefly explain how this works in practice. Step 1 is always the application in the home country. For employees, the application is generally filed by the sending employer, not by the employee. In a case from Austria to Japan, the competent authority is Austria and the application is submitted electronically via ELDA, the elektronischer Datenaustausch. Importantly, from the Austrian side, no additional documents are required. The certificate of coverage is issued solely on the basis of existing compulsory insurance registration data. For an application, on the other hand, in Japan, further documents like employment contracts, secondment letter, host company details, posting duration, confirmation of ongoing home employment might be necessary. Once issued, the certificate confirms that the social security law of the home country continues to apply, normally up to 5 years, unless an exemption has been granted for a longer period. The certificate is then presented to the respective authority in the respective host country, and the exemptions as outlined before will apply. Self-employed applicants, they apply directly to their home authority to evidence the residence-based coverage. What is now the totalization, which we heard a few times already in this presentation? Totalization combines Austrian and Japanese coverage periods to meet the minimum qualification periods, but each country pays only for its own periods. This matters because Japan requires 10 years and Austria requires 15 years for pension eligibility. And totalization prevents loss of rights for employees who worked in both countries. But remember, totalization secures only the entitlement, not the benefit amount. Each country then calculates a theoretical full pension, then pays a pro rata share based on its own insurance periods. The agreement explicitly mentions pre-treaty periods are fully counted, and lump sum refunds can cancel totalization rights. So this is important. So after having worked in Japan, for example, for 3 or 4 years, you have the choice when leaving Japan to get a one-time payment as a lump sum to balance your pension claims immediately. But in such case, the 4 years are gone for the counting for the totalization. Then at the end, cross-border workers can submit pension applications in either country, regardless of where the pension was earned. For Austrian pensions, applications can be filed at the Japanese pension offices. On the other hand, for Japanese pensions, also Austrian pension office might be applicable. Local authorities coordinate to process the claim so that periods in both countries are recognized for eligibility. This reduces multiple filings and simplifies also HR workflows. Okay, so this was the summary of the major issues. Please understand that such a social security agreement is rather complex topic, and we try to target the most important points, but we're not able to cover, of course, all the issues. We understand that each case of working abroad has its own specialties, and there are certainly very specific questions that might not have been targeted yet by these presentations. But I think we are now happy to go on into our Q&A sessions, and we are also happy to have our experts from the Austrian side on board, who are also now able to answer specifically questions, also specifically regarding the Austrian side.
Yes,
thank you.
Thank you so much, our experts from City-Yuwa. And I think this is the time now for Mr. Böltl joining us from the Austrian Ministry to add a few, remarks, particularly in regard to the length of business trips, so to say. Please, Mr. Böltl, go ahead. I think we can hear you. Yes.
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 Thank you for giving me the floor. I'm happy to make some remarks about this very good presentation. Nevertheless, we have some remarks. Yeah, and greetings from Vienna. Actually, my name is Manfred Böltl. I'm the head of unit of the international unit department in the Ministry of Social Security. At that time, when the agreement was negotiated, it was still my predecessor in charge, and I'm now the head of unit for almost 2 years. But of course, I was also I'm aware about the agreement, and so I have some comments I want to make. First of all, the agreement with Japan, in principle, it's a classical bilateral agreement that we usually conclude. So it covers applicable legislation and pension insurance. However, there's one special element within this agreement, because it was the explicit wish of the Japanese side to deal with the residence requirements, the requirements for legal stay in Austria, also within this agreement. This was the first time that this wish was expressed by one of our partners, and that we directly dealt with it in the agreement. And that's the reason why we have this, for posted persons in particular, we have this double insurance also in health insurance and sickness accidents insurance. The Japanese side, they don't have a specific scheme for accident insurance, only Austria, and that's the reason why for Austria it's health insurance and accident insurance, and for Japanese side only health insurance. So in other agreements, we have the principle that when a person is posted in all branches of Social Security, which are covered by the agreement, this person remains only insured in the system of the sending state, whereas in this agreement, and this is particular for this agreement, we have the specific situation that the person only remains covered in the pension insurance and the unemployment insurance of the sending state, but for health insurance and accident insurance, this person has this double insurance in the sending state and in the state of work. This can be Japan or Austria, because it was the explicit wish of Japan, but we then introduced this provision for both sides, of course. So also when a person is posted from Austria to Japan, we have this double insurance in health insurance. So just to clarify that, about this extension, it was said correctly that we have this requirement for a posting that at the beginning of the posting, it must be expected that it will not last longer than 5 years, but then it can be extended with an agreement between the authorities of the two states. Just to clarify this must be the real expectation at the beginning of the posting. So you cannot simply write into the contract 5 years and then it lasts longer. If it was clear that this was not the correct assessment, then this considered to be fraud, and then this can be the situation can be changed retroactively. And another remark about extensions and agreements on exceptions. This is not a right. This will, as was correctly said, will be decided by the authorities in both states on a case-by-case basis. And of course, we are always open. If there are justified reasons for an extension, we do not want to be. We always want to support economic activities, but there is no right to do so. Then next remark about business trips. There was slide 13, that business trips don't fall under the agreement. We don't agree with that. For us, business trips is a posting, yeah, it's a short posting. And this is the same rule also under union law. So under union law, also there are some people think that business trips are something different, that is no posting, but this is not true, and this is our standing related also to all our bilateral agreements and to union law, that business trips is a short-time posting and falls under the agreement, and the rules about posting apply also to business trips. I come to an end quickly. For self-employed, the reason for this special provision we have here, that if a person would be covered in both states, then only the legislation of the member state of the contracting state of residence applies, is that the Japanese side, they wanted to have a posting rule also for the self-employed, but actually we Austria, we never have posting rules for self-employed in no bilateral agreement, and so we looked for another solution, and then this was the compromise that we agreed upon. And last remark about the calculation of pensions. It was said that both countries calculate pro rata. Actually, this is not correct. We have calculation provisions, different ones for Austria and for Japan, and we proceed in the same way as we do in the European Union, because the principle is the same. Under our legislation, it makes no difference if we calculate pro rata or if we calculate directly, only applying the Austrian calculation rules, and therefore we don't need to calculate in the European Union pro rata, because it would make no difference. And that's why we have also introduced this principle also into this bilateral agreement. So this is just a technical detail, just to tell you that we don't calculate pro rata, we calculate in the same way like under union law, and so it is guaranteed that the rights of the persons concerned are guaranteed. So, and this were my remarks on the slides. We are happy now, if necessary, to answer questions in the Q&A session. And I can understand that this was quite a lot of information, also very complicated on some slides. So I can offer you that if you have questions later, that you can always send an email to us, and you can, of course, always ask the ministry about questions of application of this agreement. Thank you.
Thank you, Mr. Bölkel. That's very generous and very helpful. Of course, I think some of our attendees will definitely use that opportunity. I really thank all the experts for joining us today. It was extremely helpful. Very grateful that you all took your time. Yes, as we said, so if there are follow-up questions, we will, of course, try to follow up with them. Thank you very much for joining us today. As you can see, we are here for you, your office, for all the Austrian companies, your office here in Japan, and happy to receive more inquiries. Thank you, everyone, for joining today. Thank you.
Thank you.
Thank you.
Thank you. Bye-bye.
Bye.